Good morning to all and welcome to our webinar. I'm Suresh Iyengar. I'm a business advisor for North Central Texas Small Business Development Center. We are a leading provider of assistance for small businesses. We are also grant funded, which allows us to offer services at no cost to you, the business owner or entrepreneur. Today's webinar is titled Employment Law 101 by Ashley Smalley. This is a quick reminder that we will be recording this webinar and then adding it to our YouTube channel. Today's webinar will be interactive, so please feel free to raise your hand, which is the small button at the bottom, if you have a question or comment. Again, our presenter is Ashley Smalley, the founder of Smalley Consulting, a human resources consulting firm. Ashley is a certified human resources professional, trusted consultant, and facilitator in the sphere of workplace culture. She uses the perspective to equip organizations of every kind with the essential skills they need to foster unity within their teams. Welcome, Ashley. Please take it away from here.
Okay, thank you, Suresh. I appreciate that so much. Let's see. I am excited to be here. Does everything look good to you still? It looks a little different than it did earlier, just making sure it looks good for y'all.
Yeah, it looks good.
Wonderful. Well, I am so excited to be with you today and to be talking about employment law. It's not a it's not a particularly sexy topic, and that's okay. It is something that's necessary for business owners to know. I myself own a small business and am familiar with the needs of a small business owner, but I was in HR for almost a decade in a larger corporate setting. And so what I'm sharing with you today, actually, we've got a series going, and it's like things that small business owners need to know as it relates to employment. And so this session, we're going to talk about Employment Law 101. And the next one, while I'm going to touch very briefly today on harassment and sexual harassment and discrimination specifically, we've got a whole course scheduled for that in a couple of weeks where we'll really dive deeply down into that particular topic. And then to try to balance out just the dry content of those two things, we will talk about the importance of leading with laughter and a benefit that we experience as leaders when we do so. What I feel like I have to tell you, I absolutely must tell you, is, I'm not an attorney. And so we're talking about employment law things today, but I'm just sharing with you what I have learned and hoping that you will take away, at least with some curiosity, perhaps the things that would apply to you in your business. My best recommendation would be if you have an employment law thing come up, if things start to feel some kind of way, it would be really good to engage an employment law attorney, very specifically an employment law attorney, because they're going to know all of the laws that we're talking about today inside out. That's going to be what they deal with. And I know some of us, when we're in small businesses and we're working on small budgets, we're like, well, I have a friend who's in family law. Maybe they can help, and maybe they can. But employment law gets really intricate, and it gets really expensive when it's not followed to the letter of the law. And so just want to share that piece of advice with you and then tell you the rest of this is not legal advice whatsoever. So let's dive in a little bit. We're going to basically be looking at some of the biggest laws that apply to employers in terms of how we are treating the employees who work for us. I think I want my focus to be, here's the law, and the law can occasionally be really frustrating to try and implement and follow, particularly as a small business owner. However, the intent of these laws are to make sure that employees are being treated well, and they're being treated valuably. And so while it can sometimes be a little bit frustrating to try and implement, I have to get to the place where I'm like, okay, but I do really care about how people are being treated and how they feel when they're at work. And so this is a way that I can work to that end. So let's look at the first law. It's going to be Title VII of the Civil Rights Act of 1964. And sorry, my computer is having a moment, which, happens mostly because it involves me. So there we go. Title VII of the Civil Rights Act of 1964. I hope that somebody who's watching this went like, yeah, I feel that on a really intimate level. Thank you for the head nod. I appreciate that so much. So Title VII of the Civil Rights Act of 1964. Basically what Title VII is the law that prohibits discrimination or harassment based on an employee's race, color, religion, sex, national origin. Think about what was going on in the 60s in this country. And that Title VII was put into place to try to protect those who were not being treated fairly in the US. And it's expanded. So Title VII has been expanded through various employment laws over the years. Some of those include, and this one I really like now that I'm over the age of 40, but now employees can't be discriminated against based on their age. So once you're the age of 40, you've entered a new protected class. And so people can't make employment decisions based on that age. The law was revamped to include sexual harassment. Originally, things in the 60s, it was all about gender equality, race equality. And that has been expanded to make sure that people feel like they can work freely without fear of being discriminated against or harassed based on their sex. And we'll talk in a little bit that's been expanded even further as we've gotten into the 2000s. The laws were expanded to include pregnancy discrimination so that we can't negatively impact someone because they are pregnant or could become pregnant. Also, in 1986, the Supreme Court held that sexual harassment is also sexual discrimination. So they expanded the definition so that if you're harassing someone, you're also discriminating against them, and everything that's in Title VII applies. In the 90s, the Americans with Disabilities Act came into play, and we'll look at that one a little bit specifically and how we can protect and care for those employees who are disabled. And then the same-sex sexual harassment came into play in 1998. Now, if you'll give me 2 seconds, I'm going to mess with my computer for just a second because I'm realizing that what you are seeing is still not what I am seeing. So let's see. Let's try this. Is that better? Probably not. We get online and we check these things so that they work, and then they just have a complete change of opinion, I guess, whenever. So give me a sec. What I'm going to do is I'm going to stop sharing, and then I'm going to re-share and see if that will work a little better for you. So sorry about that, y'all. I just want you to be able to see what we're actually looking at. Okay. In the meantime, you can just think about the ways that you really hate it when technology won't work for you, and maybe that will make you a little more sympathetic for what's happening right now. Oh my goodness, they're gonna fire me. This will be the end. This will be the last time that they invite me back because of this. All right, we're gonna try one more time, and then we'll just. Worst case scenario, we'll figure out a way that we can share these things with you after the webinar. Let's see. I'm sharing this screen. It sure is. Okay. All right, let's try this, dude.
Are you in presentation mode? Yeah, we can see the change now.
Can you? Okay. Well, let's try. Again, I'm going to... You
can see the webinar details now.
The event details?
Yeah, the webinar details, but you had the presentation up earlier.
But you were just seeing the
Front slide, yeah.
the front slide, and I think that is really interesting. So sorry, you guys, that you're having to watch me figure out how to use a computer today.
I'm just glad it's not always just me.
Okay, thank you for that. Whoever gave that encouragement, I am so grateful for you. Okay, can we see it now? Is it looking right now?
Yay, yes.
It's working.
Yay, okay. All right. Now maybe I'm not fired after all. No, there's still time. Okay. Okay. So there's the list of all of those laws that I was saying modified Title VII, age discrimination, pregnancy discrimination, Americans with Disabilities Act, and then same-sex sexual harassment came into play in the 90s as well. And so, as I mentioned, we will spend a lot of time on that sexual harassment piece. I'm just going to hit that very high level today. Employees that meet any of the qualifications of Title VII are considered to be in a protected class. And I was hoping that maybe we could brainstorm together a little bit and see if we know any protected classes. So a protected class, as I mentioned, would be someone who's over the age of 40. So that's a protected class. Can you guys think of any other protected classes?
Yeah, disability.
Disability, absolutely.
Somebody that's technically challenged, maybe.
Nice try, Roger. I have not seen that as a protected class. However, any sort of disability, which we will look at in a minute, is a protected class. If you think about the other things that were protected by Title VII, they were race, religion, gender. All of these things are protected classes. Now, while I've got you warmed up and thinking, oh man, she's going to make me use my mic, help me with this one. What is discrimination? How would we define that? Anybody have an idea? I can read
Treating
you
somebody,
yeah, go
treating
ahead.
somebody differently than
Yes,
you would somebody else for one of those reasons?
absolutely. The Google definition says that it's the unjust or prejudicial treatment of different categories of people. And we really can discriminate based on any number of factors. And most of those are protected classes under Title VII of the Civil Rights Act of 1964. So here's what discrimination would look like for an employer. It would be making decisions that are employment related. Things like, I'm going to fire you for being a member of this protected class. And perhaps that's something like, oh, you were not necessarily in a protected class before, but now you're pregnant. Oh, and that's not convenient for what we're doing here. And so firing based on that condition, that would be a discriminatory thing. Not providing training to people of a certain race so that they don't have the opportunity to develop and move up in the organization would be discrimination. Giving lesser job assignments to someone in a protected class could be considered discrimination, or giving the best job assignments to someone else. You know, we can perceive that we're being discriminated against based on the things that are directly happening to us, or the things that are happening that are positive for others that we are not experiencing. Things like promotions. If we perceive that our pay is not equal, that could be considered discrimination. Offering different benefits to different religious groups, that would be discrimination. Choosing layoffs where we only lay off, let's say, minorities, that would obviously be discrimination. Providing different leave classes for different groups of people could potentially be discrimination. So basically, what the law says, if you just boil it down, what the law says is you can't make employment decisions based on anything related to a protected class. Your employment decisions should be made solely on the work that the employees are doing. And I've worked in this, let me give you like where it gets kind of hairy. When you start thinking about things as a small business owner, and let's say you're looking to hire an admin assistant, and as you're interviewing candidates, there is a candidate on paper whose experience and reference checks, everything, man, they are phenomenal. but you notice when she comes for the interview that she's 6 months pregnant, and you're looking at it going, man, as soon as I get her on board, she's going to be out on maternity leave. If you make a decision based on that characteristic, that protected class pregnancy, that's considered discrimination. And that's where it gets really hard. And there is so much gray area in terms of what do you do? How do you walk through this in a way that honors the law and honors the human and also meets your business needs? And I'm not here to say, here's what you should do, but I am saying that is something that you should consider, and you should know that that's considered discrimination. What would you say harassment is? If that's discrimination and treating somebody differently is discrimination, what would you say harassment is?
Maybe like singling somebody out and not treating them correctly in front of their peers potentially.
Okay, so I hear you talking about what it feels like for them to be at work and the way they're being treated in front of others, which could speak to a hostile work environment. So yes, harassment could be that. Any other thoughts that anyone wants to contribute?
It feels like an overt behavior. An overt.
An overt behavior where it's very obvious, it's very pointed, and there's no getting around it. Absolutely, that sometimes is the case. If you were to look at the definition of harassment, it's going to say continued and regular unwanted actions against a person or a victim. It will be behavior that's demeaning, humiliating, intimidating. It could be words or behavior that's threatening. It's always going to be unwanted. It's going to be uninvited, and it's going to be unwelcome. And those are kind of the things to keep in the back of your mind. I'm kind of a joker, and I tease and joke in the way I was raised. We always say, like, this is how we show love. But I have to make sure that I'm not crossing a line that makes someone else uncomfortable, right? If I tell that my joking is unwanted by them, I'm quick to apologize and to not go back down that road again, and just paying very close attention to how people are responding, because if it's unwanted, uninvited, or unwelcome, it becomes harassment very quickly, particularly if it persists. So let's say you've got an employee that comes up and they make a harassment claim. They say somebody is either discriminating or harassing me based on the fact that I'm a woman, or based on the fact that I'm over 40, or based on the fact that I'm Mexican. What do you do with that? Because as small businesses, we don't necessarily have HR departments set up ready to take those complaints, right? So what do you do? Well, the first thing is, if you have a harassment policy, and I know not all small businesses have policy manuals and all of that, depending on the size. It's tricky because small could be 1 to 2 employees, and small could be up to 50 employees, depending on how you're looking at things. And so sometimes we don't have policies, but if we have them, we want to make sure that we're following them to the letter. Whatever we've lined out as the path that should be taken when there's a claim, we need to follow it. People really want to be treated with dignity and respect, and they want to know that they're being heard. So we just want to make sure that we're willing to listen and take seriously what's being brought forward and not dismiss it. We want to respond as quickly as possible. And I know, as a small business owner myself, there could be 300 emails that are pressing, or the phone's ringing, or a client needs this, and I'm looking around going, who's going to do it? Well, I guess it's me. When in the world am I going to get to this claim? If you have a harassment claim, just know it needs to kind of jump the line and become a priority, because if it doesn't become a priority in your mind, then the employee who's making the complaint feels like it's not being taken seriously, and like they're not being respected, and they're far more likely to do something legal with that complaint if they don't perceive that it's being taken seriously. If you do have an HR department, use them. If you don't have an HR department, this is really where an employment law attorney is nice to have. Or if it's not a major claim, but you're like, I don't know what to do with this, an HR consultant can be really useful just to give you basic guidance on the law. Or if you just have a friend who's in HR, you can kind of ask their opinion. I always had this perception. I could kind of tell when this is, I just want to be heard. And when it was like, this is about to blow up. If you have any gut feeling that this is about to blow up, it's time to skip your HR friends and find an employment law attorney for sure. So that's what to do when there's a harassment complaint. Here's what to not do. Don't ignore it. Don't brush it off. Don't act like you think it's silly. Hear me, even if you think it's silly, even if you think somebody's just being overly sensitive, that needs to never come across, because as soon as it does, they feel like it's not being taken seriously and they'll try to escalate beyond you to a compliance agency outside of the organization. If you've got multiple layers of management, so there's you, and then there's some mid-level managers, and then there's the employee making the complaint, do not make them follow the chain of command, because especially if the manager that they have is the one that they have a complaint against, you're asking for trouble. But I've seen employers do this. So it's a good practice to have just an open door policy where any chain of command can be jumped and you can go directly to the top if that's what you need to do to make a complaint. If you get a complaint and you're angry about it, let's say the complaint's against you, don't send messages in writing. Do not, this is me talking HR to you right now. Do not create a record that can be traced, particularly when you're angry or you're having your initial emotional response to that complaint. And then also don't tell anybody else about the complaint. Keep it as confidential as you possibly can. There will come times where you have to investigate and ask questions, but to the extent that's possible, nobody else needs to know about it. You don't need to be talking to the other managers over other divisions. Keep that under your hat. The only people, it's a need to know basis, and very little people will actually need to know. I wanted to look at a couple of types of sexual harassment. For anyone who's unable to attend that series or watch that series here in a couple of weeks, there are two types of sexual harassment that come into play. There's a hostile work environment, which we'll talk about, and there's quid pro quo. And quid pro quo is this for that. It's kind of what we tend to think of when we think of sexual harassment, where a manager or a business owner is trading employment benefits for sexual favors. And that is a disgusting display of power, and absolutely is sexual harassment. But there's this more subtle category, and that's the hostile work environment. It's where there are things happening that may be severe. You know, it could be a groping, a touching, or whatever. Or it could be that it's just pervasive. It's small things. It's comments here and there. It's a look, it's a facial expression, it's a tone that's being used over and over that makes it uncomfortable to be in the workplace. And so we want to, the important thing that you take away is that both of those are sexual harassment, whether it's direct and overt and in your face, or whether it is a trade-off so that you can get overtime or not get written up for being late, or if it's, you know, you just keep sending me sexual jokes and I've asked you to stop and you just keep doing it. All of that counts as sexual harassment. The other thing I wanted to mention here is that there are some things that we maybe wouldn't have originally considered sexual harassment that since about 2012 have kind of been changed. The EEOC ruled that employment discrimination on the basis of gender identity or transgender status is prohibited under Title VII. So you can't discriminate against based on somebody's gender identity. No matter what your thoughts are about it, it's irrelevant. According to the law, you cannot discriminate based on that. That falls under sexual discrimination or harassment. And then in June of 2021, the EEOC issued guidance that, and you probably have seen this, if you have a LinkedIn account and you see people have their name and then in parentheses their pronouns, she and her or he and him, that came about after this EEOC guidance was issued that says if somebody asks you to use a name or pronouns that you associate with a different gender from what they appear to you, and you refuse to use that name or those pronouns, that's considered sexual harassment. And that's one that not everybody knows about. And it's important to know, regardless of what your feelings are about that whole topic, what we're trying to do and what the law is trying to do is create an environment where people can come to work and feel safe and feel comfortable. And as employers, our job is to make that happen. In that same law, and this is very controversial and it's back and forth all the time, transgender employees were given authority or permission to use the bathrooms and the locker rooms that coordinate with the sex they identify with. And so if you happen to have a big enough facility where there are shared restroom spaces or whatever, or locker rooms, just know that that is a wonky, messy thing that is out there. But that's what the Supreme Court ruled back in the early 2020s. Okay, let's look at the Americans with Disabilities Act. This one, let me just say, I don't think employment law is ever clean. I think it's just always muddy, because really what they're trying to do is create laws that will cover everyone. And then there are so many intricate circumstances that they just keep adding provisions, and it's hard to make it match always. And so the Americans with Disabilities Act is no different. It was modified in 1990, but it is set up to protect individuals that have disabilities or those who are regarded as having disabilities. And in the law, the definition of disability is an impairment that substantially limits one or more major life activities. We'll look at what those are in a second. Having a record of such an impairment or being regarded as having such an impairment. And so there are major life activities and there are major bodily functions that if they are impaired, it's considered a disability. I will tell you, after I flip the screen and show you the list, I suspect that we could fit almost anyone into a category of disabled. So let's take a look. So major life activities, if you have trouble caring for yourself, performing manual tasks, if you have trouble seeing or hearing or eating, that's considered a disability. If you have trouble sleeping or walking or standing or lifting or bending, disability. Speaking or working is a disability. If you have trouble breathing, learning, reading, concentrating, thinking, or communicating, those are all possible disabilities. So breathing, allergies falls under that. Welcome to North Texas, where we just have allergies all the time. But I remember a specific instance where we had someone that had a very sensitive respiratory system. And so any sort of scents or anything made it hard for her to breathe, gave her headaches. And so we had to go through the process of figuring out how to address people's candles and perfumes and all of that, because it was complicating her life and making it so that she was having a hard time functioning. And that counts as a disability. You can also look anything that impacts the immune system or the digestive system, the bowels, the bladder. Those are all disabilities potentially. Neurological. So if somebody has dyslexia, that can be considered that or any other learning disability is considered a disability. You've got respiratory, circulatory, reproductive functions. Okay, so what that means is if you've got an employee who's trying to get pregnant, she and her husband, or the husband and a wife who doesn't work for you, they're trying to get pregnant, and they are under some sort of treatment plan or medical attention that says, like, you must try to reproduce at these times based on your biological clock. It gets a little dicey because normally we wouldn't allow someone to leave work to go and try to reproduce. But in these situations, if there's a known medical condition, then it becomes necessary, and it could potentially fall under the ADA. Same thing with endocrine. So that's like thyroid glands, hormones. If any of these things are impeding a person's major life function, it could be considered a disability. So we can't discriminate. That's one of the protected classes. So if we were to limit or classify a job applicant in an adverse way because they have a disability, we think about it in terms of, if someone were in a wheelchair and where it's very obvious to us, and we were to go like, oh, I don't think that would work here. We know that that's discrimination if we wouldn't hire somebody simply because they're in a wheelchair. But all of these other things that you can't see once they've become known to you, you still can't make employment decisions based on that, or it's considered discrimination under the ADA. So we can't deny employment opportunities for applicants who are truly qualified. So if they're able to do the work, or if they're able to do the work with a slight modification that doesn't create an undue burden on the employer, we're supposed to make that happen and not just kind of cast them off and say, no, sorry, you can't work here because you've got this issue or this condition. There's a process called the interactive process, which we'll talk about in a second, by which the employer works through the disability with the employee to try to identify a reasonable accommodation for that condition to make it so that the employee can keep working and keep doing their job. If we refuse to do that, it's considered discrimination. Or if we make fun of someone because of their disability, or we're harassing them because of their disability, obviously that counts as discrimination as well. So what do you do when you're an employer and you find out that one of your employees has a disability and it's impacting their work? What do you do? And really, here's kind of what you want to think about. When the employee approaches you, keeping in mind the employee does not have to use the language, I have a disability and I would like a reasonable accommodation. There are no magic words. You as the employer are responsible for listening to what they're saying, what they're showing you, and identifying if an interactive process needs to take place. So if they approach you and you think, oh, this is going to be a nightmare. This is messy. I don't want to get in it. You can't ignore it. If you ignore it, you're asking for trouble, because a reasonable accommodation may be necessary, and it may be easier than you think to accommodate the issue. As employers, our mind tends to go to the farthest reaches of possibility, whatever's going to be most expensive or most inconvenient. And a lot of times it's not that. The employee just needs something minor. Can we just turn off, can we just make a policy where we don't burn candles in the office because that makes it hard for me to breathe? And we start thinking, I need to put in like a filter system and all that. It's like, no, hold on, we'll just talk about it. We'll just ask them. So if somebody approaches you with an ADA issue or something that could be an ADA issue, you just say something like, oh man, okay, that sounds important, and I need to do some research. I need to look into that. Can I get back to you tomorrow? Whatever you do. And I just feel like this is good practice in life. Don't just make up an answer. Because you need a solution. You go and you research it, and you think about it, and you find, oh, that's not actually feasible. Trying to take that back is going to be way harder than if you had just asked for time on the front end. So here's what the interactive process looks like. You say something like, okay, I recognize that you are having trouble with, let's pick something. I recognize you're having trouble with your reproductive system. Thank you for bringing that to my attention. What do you think would be a reasonable accommodation? That's a great question to ask. Instead of assuming that we know and blowing it into something much bigger than it has to be, okay, like what would make it possible for you to still address this issue? Maybe it's time off work or whatever, or maybe they need to be able to take breaks to take their basal body temperature or whatever it is. What do you need as the accommodation? Instead of the attitude or the wording, like, well, I can't do anything to help you with that. And so the principle is, can I, as the employer, provide a reasonable accommodation without any undue hardship? Now, if it's going to cost thousands of dollars for us to do what they've asked, and that's not in the budget, well, it's not, and we just have to be honest about that. But then we would say, I can't afford the thing that you're asking for. I just can't. We can't pull that off. What about this? Would this be workable? And they say no, but maybe this, and you kind of have this going back. It's a dialogue back and forth. I will tell you this, document every bit of the conversation. So if you make a suggestion, write down what you suggested. If they make a suggestion, write down what they suggested and why it wouldn't work or why it would work. And you just want to have that whole thing documented. every parry back and forth so that there's no missed information documented in case it were to come up later in some sort of lawsuit. We want to say things like, yeah, let me look into that, or let me check into the cost of that and see if that's feasible. Or let me see if there's something we can do. So in your language, you just want to be very understanding and very cooperative. Attitude will make a huge deal. If you have a business where you provide uniforms and you have an employee that has an extreme weight gain, let's say, and they need new uniforms, those new uniforms might be considered a reasonable accommodation. So there are all sorts of things that can come into play. My basic rule is, if you're able to accommodate the request of an employee without it burdening your business, probably just do it, because it communicates all the other stuff, like employment law aside, it communicates to them that they're valuable to you, that they matter to you. And I have seen firsthand supervisors and managers with the attitude of like, that's not my problem. And that communicates the complete wrong thing to employees. Supervisor attitudes will make or break the interactive process and really any conversation that you're having about how to accommodate a specific issue or disability. If it comes across as, I don't want to deal with this is inconvenient for me, that really has a negative impact for the employee and is far more likely to result in a lawsuit or a claim with the EEOC, the Equal Employment Opportunity Commission. You shouldn't share how you feel about the disability or anything like that. There's laws that prohibit you from discussing employees' medical sickness, FMLA, ADA, health issue, all of that. Like, you've got to keep that to yourself. We'll talk about that law in just a few minutes. It's called HIPAA. And making sure that we are treating all employees consistently and fairly. So you run into an issue if you've got one employee with a disability and we make an accommodation for them, but you've got another employee with a disability and you don't make accommodation for them. And now that really starts to smell like discrimination. And so we want to make sure that we're consistent across the board. The next law that I want to take a look at is the Family and Medical Leave Act. Everything that I've told you about so far, like Title VII, pretty well applies, that discrimination and harassment piece, pretty well applies to all employers. Americans with disabilities, I believe it's employers with 15 or more employees, the ADA applies to. The Family Medical Leave Act applies to larger employers, employers that have 50 or more employees within a 75-mile radius. Basically, what the FMLA is unpaid job protected leave when somebody, an employee or someone in their immediate family has a medical related issue. We'll look at what those are in just a second. Those bottom three boxes really show what the qualifier is, when an employer has to provide FMLA leave. However, what I can tell you is whether or not you have 50 employees, you're going to have stuff coming up. And if it's where you can accommodate the medical needs of your people, what you are doing in terms of building camaraderie and loyalty with them is huge. Do you have to keep somebody on if you have less than 50 employees and they have a medical issue come up? No, you don't have to. But if you can, it's the best option. And it saves you costs for rehiring and training and all of that. But it also builds rapport and good culture within your business. So I know many of you don't necessarily have 50 or more employees, but I just want you to see what is covered in case you find yourself approaching that threshold so that you know kind of what's next for you. And the FMLA covers basically any of these 6 things. If an employee or one of their immediate family members, so spouse, child, parent, that's considered immediate family member. Brothers and sisters are not, but if it's a spouse, a child, or a parent, or the employee themselves, and they have an overnight stay in the hospital or hospice or any sort of medical facility, that could be subject to FMLA. And what FMLA grants is up to 12 weeks of protected leave in a 12-month period that is unpaid but protects your job so that your job is you're not replaced while you're out on leave. If you've got somebody who, Glenda, would you mind unmuting and telling me what you just wrote in that box? And let's make sure that I haven't said something confusing.
I just wanted to distinguish between immediate family and in-laws. I've actually had that situation in a government agency, and it does not include in-laws. So the wife cannot go take care of the mother-in-law on FMLA. I did have that, and I was able to eventually save her job through other means, and she actually retired through this whole process, but she is not covered under FMLA.
That's good. Thank you for that. And also FMLA, I've never heard it said that way. You're so fancy. Okay, so we've got anything that where an employee or one of those immediate family members is incapacitated for 3 or more calendar days, where so let's say they're in the hospital for 3 days, and then they've got continued medical, like they have to continue seeking treatment, that's covered under FMLA. If they're out because of pregnancy or prenatal issues, that's covered under the FMLA. If they have a chronic health condition, so this is the messiest one of all of them, because with a chronic medical condition, I may not need to be out for 6 straight weeks. I may need to be out 3 days this month and 3 days next month. For example, one of the conditions that would be covered under the FMLA would be gout. So we used to have mechanics that work, and they would get gout in their feet. And when they had gout in their feet, there was no way they could be on their feet working. And so it was an ongoing condition, but it never really required that they were out for longer than a week or so at a time. And so then you're having to track how much time are they out in that 12-month period, and does it surpass that 12-week mark? But if not, then their job is protected even if they're having to miss. Now, here's what you need to know about FMLA. If you are big enough that you're required to provide FMLA leave, or if you just decide, you know what, I want to provide this kind of job protection for my people, and so I'm going to do it voluntarily. There are free on the web, there are FMLA forms, doctor certification forms, request forms for employees, all sorts of things where you've got very consistent documentation on these conditions. FMLA abuse is a very real thing. I one time had an employee whose wife had cancer, and so he went through the certification process for FMLA, and then would take FMLA days kind of in this chronic health condition circumstance where he needed intermittent leave. He would take those days to go spend with his girlfriend, which I thought was delightful. And so when there is abuse of FMLA, that is a terminable offense as well. That chronic health condition is where it gets really dicey, but it is covered under the FMLA. If you have somebody who is incapacitated due to a long-term condition, stroke, cancer, something like that, that obviously is covered. And then if you've got something where somebody, like the flu, okay, you've got a condition that really is probably not a huge deal, but if it's not treated, then it could go longer than 3 days. Sometimes the flu qualifies under FMLA leave, and sometimes it doesn't, and that's on a case-by-case basis, and that depends on what the medical provider is saying. One thing I want to draw your attention to is that the FMLA, the ADA, and if you have workers' comp insurance in your business, those 3 all work together. They all run concurrently, and it makes it very complicated. So if you've got someone who is on workers' comp, depending on how your policies are written, that could run concurrently with the FMLA. And depending on the condition that they're out for, that could also potentially be a disability that's covered under the ADA. And so you can't just go, okay, I've got somebody on FMLA or I've got somebody on workers' comp and they've been out 12 weeks and they're not better, and so I'm cutting them loose. There is the potential that you've got to consider it from the ADA standpoint. go through the interactive process, find out if there's a reasonable accommodation that can be made. If your policy is not written so that workers' comp and FMLA run concurrently, then an employee could try to stack those on top of each other and prolong the time that they're out on leave. And so those are things to consider. I will tell you that I have made more employment law phone calls, calling attorneys on employment law, specifically as related to FMLA, workers' comp, and ADA than anything else in my career. So if you have issues with those three specific laws or any one of those three, that's the time to phone a friend who is an employment law attorney. Okay. I guess that's been a whole bunch. Before I move on, does anybody have any questions about any of the things we've talked about so far?
I put a question in the box, but I'll just go ahead and ask it. Would like a autoimmune disorder where they have flares over, a period of time, is that something that's considered?
Yes, under the FMLA, yes, and potentially under the ADA as well. And so there are different forms that doctors fill out. So if you're working under the FMLA, there are different forms for a one-time condition, where I'm hospitalized because I had hip surgery, or an ongoing chronic condition where then the doctor has to give you more information about how often are flare-ups likely, how long will a flare-up likely last. Of course, knowing that those are not always spot on, but yes, they're absolutely protected by the FMLA and potentially could fall under that endocrine, hormone, all of that piece of the bodily function that could be impacted, in which case it falls under the ADA as well. It's a great question. Thank you.
Thank you.
Anybody else with any questions?
I don't have a question, but we use JAN, the Job Accommodation Network.org, jan.org quite a bit. So I just think it's an awesome resource if people are, looking for help with ADA and accommodation. There's an employer live chat that you can go and ask questions, and they can provide some really awesome feedback and things to consider, maybe some accommodations that could be given for a certain situation. So just a good tool for your belt.
Lauren, thank you for that. That's not one that I'm familiar with. And so thank you for that resource. And it did make me think of another. You don't have to be necessarily an HR professional to belong to SHRM, which is the Society of Human Resource Managers. But with SHRM, it's similar. So if you have an annual membership for that, there are all sorts of articles and descriptions of the law and how to apply it. But also there's a chat feature where you can request, what do we do in this situation? It's like ask an HR professional, basically. How do I make this work and be in compliance with the law? And they won't give legal advice, but they will give high level overview. And so that's another great resource. Thank you, Lauren, very much for that thought triggering resource. We appreciate that. Okay, anybody else? And then if not, we're moving on. Good. Okay. So the next one is the Health Insurance Portability and Accountability Act. Nobody knows the name of that. It's HIPAA. And really, here's what you need to know about HIPAA. If you are not in the medical field, you need to know very little, but here's what you need to know. It protects employees' health information, and it keeps an employer or supervisor from sharing or requesting health information about employees. So that means if an employee says, I went to the doctor, as the employer, you can't go. Why'd you go to the doctor? You can show genuine care and be like, okay, I hope it went well. If you need anything from me, let me know. My experience is there are those who are oversharers that will share everything and now you know it and have to do something with it. And there are those who are very private and don't want their information shared. And so you just need to know you can't request. And if somebody shares with you, you cannot freely share that with anyone else. The other thing employers need to know is any health information. So let's say it's FMLA documentation, or let's say you have a business where you have commercial truck drivers and they have to get their medical cards redone every year or two. Any sort of medical documentation that is turned into you must be kept in a separate file from the employee's main employee file. The reason is the thought process behind that provision is that if someone were to get a hold of your employee file, they would know all of your medical history and they could discriminate based on those conditions or those potential disabilities. So it feels kind of like a pain in the tail, but if you even get a doctor's note to cover an absence and it says more than the doctor's name, the patient's name, and the date they missed, if it gives any detail, it's really supposed to be kept in a separate file. And that's really all I'm going to dig into HIPAA at this point. But if you have other specific questions, we can try to track those answers down as it relates to your industry. The next law that I want to touch on is the Fair Labor Standards Act, or the FLSA. It's been around a really long time, and it is the one that kind of shapes what we know about working in the workplace. The FLSA is what established a 40-hour work week in a 7-day period. It's the law that established minimum wage. It's the law that said, okay, if somebody works more than 40 hours in a 7-day period, they've got to be paid time and a half overtime. And it's the one that said that we're not to, oppressively hire children into child labor, which I feel like is a good law. And so the FLSA is everything that we know, but there's some nuanced things that we may not know as employers that I wanted to share just as a means of protecting your business. If an employee works unauthorized overtime, I know that the tendency is to potentially say, I didn't authorize it, so I'm not paying it. And you really can't do that. If it was worked, it must be paid. If it was worked, it must be paid. If they didn't, if they worked without permission, that becomes a disciplinary issue or a coaching opportunity. But according to the FLSA, if it was worked, it must be paid, period. In the private sector, there's no such thing as comp time. There's where you work over 40, and so you bank up these extra hours that you can take later. Like that's a thing that happens in local government for like police departments, for example. But in the private sector, if they work it, they get paid. Now you can allow them flexibility in their work week, where I had to come in really early for a meeting that happened at shift change this morning. And so I get to leave early on Friday. You can allow flexibility of time within that 7-day work week, but you can't let them bank up comp time to use later. If they worked overtime, they must be paid overtime. In the state of Texas, and most other states, there is not a requirement that you There is not a requirement that you provide break periods for employees. That there are some exceptions to that based on industry, safety sensitive functions typically. But for most employers, we don't have to allow breaks. If we do offer breaks and they're less than 20 minutes, they're typically paid breaks. If it's a meal break, which is defined as 30 minutes or more, then that's different and it doesn't have to be compensable or paid. So as an employer, we can always be more generous than the law requires, but we can never be less generous than what the law allows for. And so I got that question a lot, like, am I not allowed a break? Well, yeah, you're allowed a break, but I'm not required to give you one. And so that's a feel thing. You do that as it makes sense in the context of your organization. I would say make sure you're applying it fairly and consistently across all employees, at least within that division or that function. And then even better if it can be consistent all the way across the board. If you have people that take smoke breaks and they're less than 20 minutes, they're paid. But if you have somebody who in that same team doesn't smoke and you're not allowing them to take breaks, that's asking for trouble. And so you just want to be consistent across the board with that. The other thing I wanted to bring to your attention is that really we should never alter an employee's time card, particularly as a disciplinary action. So they've done something wrong, we shouldn't be docking their pay for that. That's something that needs disciplinary action. It needs written documentation. Like they could be suspended and lose pay that way, but to just go in and go, you know what, that was a really dumb move. I'm pulling 30 minutes out of your pay. We can't do that. That's illegal. Occasionally, we can need to alter a time card because somebody forgot to punch in, or we realized they did work after hours, or after they got home, they took emails, and we need to go in and we need to add time in. We can alter their time card, but my best practice suggestion would be always make a note as to why you altered it, what caused the change, what happened, and why and who altered it. That will help you a lot if it ever gets called into question. If you find an employee sleeping on the job, the tendency might be to, like, I worked in a place where there were security cameras and stuff. And so if you looked and you saw that somebody was asleep for 45 minutes, the desire then is to dock those 45 minutes that they were asleep. Or if you tell them to take a lunch and they don't take a lunch, to dock their time. And really, according to the FLSA, if they're on the clock, they should be paid. And then we address all of those other things as disciplinary issues. The other thing I wanted to point out under the FLSA is that really, as far as withholding pay goes, we cannot tell somebody, I'm holding your check until you get all your uniforms turned in, or until you get all of your equipment turned in. I'll hold this check until you get it here. I mean, you can say it, but technically you can't do it. They should be paid on their pay schedule, whether they've turned stuff in or not. And so as a general rule, what I would do if I had company issued equipment or uniforms that I needed to get back, as soon as they gave notice, or as soon as we gave notice to them that we were freeing them up to pursue other opportunities, we would tell them, okay, you've got until X, whenever we were going to run payroll, you've got until X to get that turned in, or it will be withheld from your paycheck. Now, you can only withhold from their paycheck for things like uniforms, any sort of company issued equipment. If you offer insurance and you're withholding, insurance premiums or anything like that, you've got to have written permission from the employee to do that. And you can do that with a simple one-page form that says, like, anything you might withhold from a paycheck, they've got to sign off on the fact that they have done that. I believe in the state of Texas, if you let an employee go, you've got just a handful of days. I think it's 3. No, is that right? Now I'm questioning everything. I can tell I haven't run payroll for like a real big business in about 3 years, because my brain is completely fried about that. If you let them go, you have to pay within, is it 7 days? Glenda, you know what? You know everything. You knew all of the stuff about the FMLA. How many days is it in the state of Texas? Glenda's like, I'm not answering that on camera. You think it's 3. Okay, I thought it was 3 as well, where we've got to cut a special check, even if it's off the payroll cycle, to make sure that they are getting those things. It's under the Texas payday law. See, I knew you should be teaching the class, Glenda. And so the other thing that I wanted to share is, well, I lost it with the Texas payday law. Okay, maybe let's do this. Maybe you guys ask questions on this last set of laws that we talked about, and I will see if that triggers anything else for me. Many fast foods do not do that. Oh, you're talking about in the 3-day mark? Linda, you can also unmute and just talk to us if you want to.
What happens, I face this with Chick-fil-A there in Midland. He was withholding their paychecks until because they didn't give notice, they just didn't show up. Well, that's not a reason. And because they hadn't returned their uniforms, and that's not a reason. I actually went through their personnel files and gathered up a bunch of past paychecks and just, had them all reissued and cleared him. But I think that is probably more the norm than not in the fast food industry with teenagers. Mm-hmm. So parents really need to be on the lookout for that, because if their kids work, they deserve to be paid. The end.
They do. And yes, we want them to learn how to leave with dignity and all of those things.
Yep.
But
Yep. And I've had those conversations with parents. This is a teaching moment for you.
Absolutely. Absolutely. And really, again, let me go back and say all of these laws were intended to protect employees and to set them up to be treated with respect by employers. And now that we find ourselves in the employer role, We just want to make sure we're doing the same thing for our employees. And yes, sometimes they are quite frustrating and do all sorts of things that we think they shouldn't do, and they are not fair or respectful of the employer. And yet we can choose to be the kind of employer that treats people right, no matter how people are acting.
I presented it to my franchise owner as I'm protecting you, the employer. I'm
Yes.
protecting you from being sued because you've got plenty of possibilities sitting in your personnel files. So, and
Absolutely.
he agreed. He said, thank you. He said, thank you. We reissue checks and we're done.
Well, and I think it's important to know that there are a lot of people in business who don't know these laws. They wanted to be a business owner, they wanted to be an entrepreneur, and they just started. And great, that's everybody that ever started a business. But if you've never been in a corporation where there was a dedicated HR team where those things are being taught, you just don't know them.
Right. And
And
he
so-
didn't. I don't think he did.
Good. Okay, any other questions from anyone else?
No, just a comment, Ashley. I think that's the majority of small business owners is that it's just not what they, follow or look for. They're just in it to run their business and do what they're doing. So this is really great to just tune them into some of that.
Oh, good. Thank you, Roger. I think it's you don't know what you know until you know it. But once you know it, now you're armed to treat your people as good as possible. And Suresh said at the beginning, Smalley Consulting, my business is all about building unity on teams and helping people feel respected. And following these employment laws is one of the ways we can do it, as frustrating as they can be at times. So I also want to draw your attention to the SBDC because they've got so many resources available. And I was delighted to find out that one of them is they actually have employment attorneys that they can recommend to you if you find yourself in a position where you need legal advice to protect your business while you are dealing with an employment law issue. And so with that, I'm going to turn it back over to Suresh and let him give you any other information that he is needing to give you.
Thank you so much, Ashley. You've shared so many topics on these sensitive areas for business owners. I'm sure they can take appropriate action. For all the viewers, we'll be sending out a survey so we can get feedback on this program, this webinar. I will now be sharing the upcoming webinars. This is not the end. We have more coming up. As you can see here, we have the one that's coming up on the 5th, your mission and how it reflects on your tax return. 17th, equipment purchase with a related loan. 17th again, tough conversations. 18th, and so on. You can see all of this at our website, sbdc.nctc.edu. What else can you do there? You can register for webinars. You can get contact information. You can also schedule an appointment with an advisor. You can also get resources for small business owners. I would like to now take a moment to thank our funding organizations, the Small Business Administration, the State of Texas, North Texas SBDC Regional Office, and the North Central Texas College. Thank you all for joining today and look forward to seeing you next time. This concludes our webinar.